Good morning, everyone. We are Group 2 who will be reporting for today's session. Our team is comprised by 3 people, myself, Mariel I. Telebrico, who will be discussing the first 5 cases. Second, we have Ray Paulo Paso Manero, who will be discussing the next 5 cases. And lastly, we have Alexandria Ramos, who will be discussing the last 5 cases. Our discussion will cover the following cases under the topic of first, separation of powers and delegation of powers; second, Article 6 of the 1987 Constitution, which is the Legislative Department; and third, Article 7 of the 1987 Constitution, which is the Executive Department. Let's now dive into the first case, which is Abacada Guro Party List versus Executive Secretary. The facts of this case are as follows. On May 23, 2005, the enrolled copy of the Consolidated House Bill No. 3555 and Senate Bill No. 1950 was transmitted to the President of the Philippines, who signed the same into law the following day. Thus came Republic Act No. 9337 with the intention of amending sections of the 1997 National Internal Revenue Code. It has the effectivity date of July 1, 2005. However, before its effectivity, petitioners Abacada Guro Party List filed a petition for prohibition on May 27, 2005. They questioned the constitutionality of Section 4, 5, and 6 of RA No. 9337, amending Sections 106, 107, and 108 of the National Internal Revenue Code. These questioned provisions contain a uniform proviso authorizing the President, upon recommendation of the Secretary of Finance, to raise the VAT rate to 12% after any of the following conditions have been satisfied. First is when VAT collection as a percentage of GDP of the previous year exceeds 2 4/5. Second, when national government deficit as a percentage of GDP of the previous year exceeds 1 1/2%. Petitioners argue that the law is unconstitutional as it constitutes abandonment by Congress of its exclusive authority to fix the rate of taxes under Article 6, Section 28 of the 1987 Philippine Constitution. The issue in this case is whether or not Sections 4, 5, and 6 of RA No. 9337, amending Sections 106, 107, and 108 of the NIRC, giving the President the standby authority to raise the VAT rate from 10% to 12% when a certain condition is met, constitutes undue delegation of legislative power to tax. The court ruled in the negative, stating that there is no undue delegation of legislative power, but only of the discretion as to the execution of a law. The court stated that the principle of separation of powers ordains that each of the 3 great branches of government has exclusive cognizance of and is supreme in matters falling within its own constitutional allocated sphere. Corollary to the doctrine of separation of powers is the principle of non-delegation of powers, as expressed in the Latin maxim, potestas delegata non delegari potes, which means what has been delegated cannot be further delegated. This doctrine is based on the ethical principle that such as delegated power constitutes not only a right, but a duty to be performed by the delegate through the instrumentality of his own judgment and not through the intervening mind of another. The Constitution further provides that the legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and the House of Representatives. However, these power which Congress is prohibited from delegating are those which are strictly or inherently and exclusively legislative. Purely legislative power, which can never be delegated, has been described as the authority to make a complete law, complete as to the time and when it shall take effect and as to whom it shall be applicable, and to determine the expediency of its enactment. Nevertheless, the general rule barring delegation of legislative powers is subject to the following recognized limitations or exceptions. First is the delegation of tariff powers to the President under Section 28, Number 2 of Article 6 of the Constitution. Second is the delegation of emergency powers to the President under the same provision. Third is the delegation to the people at large. Fourth is the delegation to local governments. And lastly, delegation to administrative bodies. However, in every case of permissible delegation, there must be a showing that delegation itself is valid, and it is only valid if the law is complete in itself, setting forth therein the policy to be executed, carried out, or implemented by the delegate, and second, if it fixes a standard, the limits of which are sufficiently determinate and determinable, to which the delegate must conform in the performance of his functions. Both tests are intended to prevent a total transference of legislative authority to the delegate, who is not allowed to step into the shoes of the legislature and exercise a power essentially legislative. Thus, the legislature may delegate to executive officers or bodies of the power to determine certain facts or conditions or the happening of contingencies on which the operation of a statute is, by its term, made to depend, but the legislature must prescribe sufficient standards, policies, or limitations on their authority. The court ruled that this case is not a delegation of legislative power, but simply a delegation of ascertainment of facts upon which enforcement and administration of the increased rate under the law is contingent. The legislature has made the operation of the 12% rate effective January 1, 2006 contingent upon a specified fact or condition. It leaves the entire operation or non-operation of the 12% rate upon factual matters outside of the control of the executive. Therefore, no discretion is exercised by the President. Thus, it is ministerial upon the President to immediately impose the 12% rate upon the existence of any of the conditions specified by the Congress. The second case is the case of Greco-Belgica versus the Honorable Executive Secretary. The case before the court is a petition for certiorari and prohibition assailing the constitutionality of the lump sum discretionary funds in the 2014 General Appropriations Act. The case started when the court rendered its decision in the Belgica versus Ochoa case, declaring certain provisions of the 2013 GAA unconstitutional. Republic Act No. 106-33, or the 2014 GAA, was subsequently passed on, and it appropriated funds for the operations of the government for fiscal year 2014. Petitioner filed the instant petition seeking to declare all lump sum appropriations in the 2014 GAA unconstitutional, including the specifically assailed appropriations, which are the unprogrammed fund, the contingent fund, the e-government fund, and the local government support fund. Petitioner asserts that the lump sum discretionary funds in the 2014 GAA were passed in violation of the Constitution, since these funds are of the same character as the pork barrel funds, which were declared unconstitutional in the 2013 Belgica case and should thus be prohibited. The issue in this case is whether the lump sum appropriations in the 2014 GAA is unconstitutional for granting the President unfettered discretion in disbursing the funds in favor of the LGUs and for the lack of guidelines in the disbursement of such funds. The court held in the negative and stated that the 2014 GAA sufficiently specifies standards which set the limits of the executive's authority to disburse the fund, and it also identifies the conditions under which the fund may be utilized. The main issue in this case is the constitutionality of the lump sum appropriations in the 2014 GAA. The court ruled that petitioners' heavy reliance on the 2013 Belgica case as precedent to argue that lump sum appropriations are unconstitutional per se is erroneous. The court stated that it is significant to point out that an item of appropriation must be an item characterized by a single correspondence, meaning an allocation of a specified singular amount for a specified singular purpose, otherwise known as a line item. The court further discussed that it must be observed that an appropriation may be validly apportioned into component percentages or values. However, it is crucial that each percentage or value must be allocated for its own corresponding purposes, for such component to be considered as a proper line item. Moreover, a valid appropriation may even have several related purposes that are by accounting and budgeting practice considered as one purpose. The court concluded that the specially assailed appropriations in the 2014 GAA are valid items with discernible singular appropriation purpose in compliance with the rule on singular correspondence. The unprogrammed fund is to fund the identified programs, the contingent fund to provide funding to meet contingencies or programs yet inexistent and unforeseen during the budget authorization, the e-government fund to fund e-government program that subsumes the strategic ICT projects of various government agencies, and the local government support fund to provide financial assistance to LGUs. Petitioner also brands the Local Government Support Fund as a purely discretionary fund given to the President to be dispersed to the LGUs without any legislative guidelines in place. The petitioner argues that it gives unfettered discretion to the President in dispersing the funds in favor of the LGUs, and because of this, it is unconstitutional. For this, the court discussed two tests. First is the completeness test, and second is the sufficient standard test. First, the completeness test. It states that a law is complete when it sets forth therein the policy to be executed, carried out, or implemented by the delegate. Second is the sufficient standard test, which states that a law lays down a sufficient standard when it provides adequate guidelines or limitations in the law to map out the boundaries of the delegate's authority and prevent the delegate from running riot. With respect to the first test, the court states that the Local Government Support Fund satisfies the completeness test. It is clear from the 2014 GAA that the policy consideration for the institution of the LGSF is genuine local development and assistance of LGUs. With respect to the second test, contrary to the argument of petitioner, the President is not granted unfettered and unabated discretion in disbursing the LGSF. The 2014 GAA provides adequate guidelines and limitations to map out the boundaries of the executive's authority in disbursing the LGSF. The third case is the case of Reyes versus the House of Representatives Electoral Tribunal. The facts of this case are as follows. The House of Representatives Electoral Tribunal published the 2015 revised rules of the HRET. Petitioner in this case challenges the constitutionality of several provisions of the 2015 HRET. In particular, she questions the rule which requires the presence of at least one justice of the Supreme Court to constitute a quorum, second, the rule on constitution of a quorum, and third, the requisites to be considered a member of the House of Representatives. Petitioner alleged that the 2015 HRET rules grant more power to the justices individually than the legislators by requiring the presence of at least one justice in order to constitute a quorum. Petitioner alleged that even when all 6 legislators are present, they cannot constitute themselves as a body and cannot act as an executive committee without the presence of any of the justices. On the other hand, HRET maintains that it has the power to promulgate its own rules that would govern the proceedings before it. The HRET argues that the requirement rests on substantial distinction because there are only 3 justices members of the tribunal as against 6 legislator members. The HRET further argues that the requirement of 4 members assures the presence of at least 2 legislator members to constitute a quorum. The issue in this case is whether or not Rule 6A of the 2015 HRET rules requiring the presence of at least one justice in order to constitute a quorum is constitutional. The court ruled in the positive. The court cited For its basis, Section 17, Article 6 of the 1987 Constitution, which provides for the composition of the Set, especially of the HRET. The provision states that the Senate and the House of Representatives shall each have an electoral tribunal which have 9 members, 3 of whom shall be justices of the Supreme Court, to be designated by the Chief Justice, and all the remaining 6 shall be members of the Senate or the House of Representatives. In accordance with this organization, it is clear that the HRET is a collegial body with the members from 2 separate departments of the government, the judicial and the legislative department. The intention of the framers of the 1987 Constitution is to make the tribunal an independent constitutional body subject to constitutional restrictions. The court further states that Rule 6 of the 2015 HRET rules does not grant additional powers to the justices, but rather maintains the balance of power between the members from the judicial and the legislative departments as envisioned by the framers of the Constitution. Rule 6A of the 2015 HRET rules requires the presence of at least 1 justice and 4 members of the tribunal to constitute a quorum. This means that even when all the justices are present, at least 2 members of the House of Representatives need to be present to constitute a quorum. Without this rule, it would be possible for 5 members of the House of Representatives to convene and have a quorum even when no justice is present. This would render ineffective the rationale contemplated by the framers of the Constitution. In addition, Rule 6A of the 2015 HRET rules does not make justices indispensable members to constitute a quorum, but ensures the representatives from both the judicial and legislative departments are present to constitute a quorum. Lastly, the last sentence of Section 17, Article 6 of the 1987 Constitution also provides that the senior justice in the electoral tribunal shall be its chairman. This meant that only a justice can chair the electoral tribunal. As such, there should always be 1 member of the tribunal who is a justice. The fourth case is the case of Romero II versus Senator Estrada. This case is a petition for prohibition with application for temporary restraining order and preliminary injunction under Rule 65 of the Rules of Court, assailing the constitutionality of the invitation and other compulsory processes issued by the Senate Committee. Petitioner herein, as owner of R2 Builders Incorporated, received from the committee an invitation which reads, "Resolution directing the Labor Committee to investigate, in aid of legislation, the liability for plunder of the former President Ramos and others for the illegal investment of OWA funds in the Smoky Mountain project causing loss to OWA of 550 million pesos. The invitation was sent by virtue of the power vested in Congress by Section 21, Article 6 of the 1987 Constitution regarding inquiries in aid of legislation. Petitioner, however, requested to be excused from appearing and testifying before the committee at its scheduled hearing on the ground that he would later substantially reiterate in this petition for prohibition. Committee then sent petitioner a letter informing him that his request being unmeritorious was denied. The following day, however, Senator Jinggoy Estrada, as chairperson of the committee, caused the service of subpoena ad testificandum on Petitioner Romero, directing him to appear and testify before the committee. Petitioner then filed the instant petition, docketed as GR number 174105, seeking to bar the committee from continuing with its inquiry and to enjoin it from compelling petitioners to appear before pursuant to the invitations thus issued. Petitioner claimed that the subject matter of the investigation is sub judice owing to the pendency of the Chavez petition. The issue in this case is whether or not the subject matter of the Senate Committee's inquiry is sub judice. The court ruled in the negative, stating that the subject matter of the Senate inquiry is no longer sub judice. According to the Supreme Court, the sub judice rule restricts comments and disclosures pertaining to judicial proceedings to avoid prejudging the issue, influencing the court, or obstructing the administration of justice. A violation of the sub judice rule may render one liable for indirect contempt under Rule 71 of the Rules of Court. In this case, however, the sub judice issue has been rendered moot and academic by supervening issuance of the en banc resolution of GR number 164527. An issue or a case becomes moot and academic when it ceases to present a justiciable controversy, so that a determination of the issue would be without practical use and value. In such cases, there is no actual substantial relief to which the petitioner would be entitled, and which would be negated by the dismissal of the petition. Courts decline jurisdiction over such cases or dismiss them on the ground of mootness, save in certain exceptional instances, none of which, however, is in this case. The court further stated that even assuming hypothetically that the Chavez case is still pending final adjudication by the court, still such circumstance would not bar the continuance of the Senate committee investigation. According to jurisprudence, Senate rules of procedure governing inquiries in aid of legislation provide that the filing or pendency of any prosecution or administrative action should not stop or abate any inquiry to carry out legislative purpose. A legislative investigation in aid of legislation and court proceedings have different purposes. On one hand, courts conduct hearings or like adjudicate procedures to settle through the application of a law actual controversies arising between adverse litigants and involving demandable rights. On the other hand, inquiries in aid of legislation are undertaken as tools to enable the legislative body to gather information and thus legislate wisely and effectively, and to determine whether there is a need to improve existing laws or enact new or remedial legislation, albeit the inquiry need not result in any potential legislation. Ongoing judicial proceedings do not preclude congressional hearings in aid of legislation. The fifth case is the case of Balag versus the Senate of the Philippines. The present case is a petition for certiorari and prohibition with prayer for issuance of a temporary restraining order and writ of preliminary injunction, seeking to annul, set aside, and enjoin the implementation of a Senate order citing Petitioner Balag in contempt. In 2017, a first-year law student of the University of Santo Tomas died allegedly due to hazing conducted by Aegis Juris Fraternity. Thereafter, a Senate committee was created in order to conduct an investigation in aid of legislation to hold those responsible accountable. Pursuant to this, petitioner was invited and several others to join a public hearing on September 2017. Petitioner, however, did not attend the hearing scheduled on such date. A subpoena ad testificandum was then directed against petitioner for him to appear before the committee. He appeared and attended the Senate hearing, and in the course of the proceedings, he repeatedly invoked the right against self-incrimination when he was asked if he headed the fraternity. Because of this, he was cited in contempt of court by Senator Poe and Senator Lacson. The issue in this case is whether or not Respondent Senate has the power to impose the indefinite detention of a person cited in contempt during its inquiries. The court held in the negative. The court stated that there is a genuine necessity to place a limitation on the period of imprisonment that may be imposed by the Senate pursuant to its inherent power of contempt during inquiries in aid of legislation. Section 21 of Article 6 of the Constitution states that the Congress, in conducting inquiries in aid of legislation, must respect the rights of persons appearing in or affected therein. The court finds that the period of imprisonment under the inherent power of contempt by the Senate during inquiries in aid of legislation should only last until the termination of the legislative inquiry under which said power is invoked.
Good morning. My name is Ray Paulo Pasamanero, and I will continue the cases under the Legislative Department. The next case is ang NARS Party List versus the Executive Secretary. The facts of the case. On October 21, 2002, RA 9173 was approved, Section 32 of which provides that the minimum base pay of nurses working in the public health institutions shall not be lower than salary grade 15 as prescribed under RA 6758, otherwise known as the Compensation and Classification Act of 1989. Joint Resolution Number 4 was approved, authorizing the President of the Philippines to modify the compensation and position classification system of civilian personnel and the base pay schedule of military and uniformed personnel in the government, and for other purposes. Thereafter, Executive Order Number 811 was signed to implement the resolution, Section 6 of which provides that the position titles and salary grade assignments of the entry level of nurses 1 is modified from 10 to 11. The issue of the case is whether Joint Resolution Number 4 of the Senate and the House of Representatives amend Section 32 of the Philippine Nursing Act of 2002. The Supreme Court said no. Joint Resolution Number 4 of the Senate and the House of Representatives does not amend the Philippine Nursing Act of 2002. After a review of compensation rates under RA number 6758, any change in compensation rate should be done by enacting a new law. Any such change amends an existing law, and such amendment cannot be done by a mere joint resolution because a joint resolution cannot amend a law. Joint Resolution Number 4, which seeks to change or revise the compensation and position classification system established by existing law, cannot take effect without a mandatory law. The revisions prescribed in Joint Resolution Number 4 are not authorized by any existing law. The Senate's definition of a joint resolution states that it is no different from a bill. However, under Section 26, Paragraph 2 of Article 6 of the 1987 Constitution, only a bill can be enacted into a law after following certain requirements expressly prescribed by the Constitution. A joint resolution is not a bill, and its passage does not enact the joint resolution into a law even if it follows the requirements expressly prescribed in the Constitution for enacting a bill into a law. As to the salary grade of nurses, RA 9173 provided for the new salary grade of nurses, starting at salary grade 15 as the minimum. RA 9173 cannot be amended by a mere resolution. An implementing resolution, like Joint Resolution Number 4, not being separate law in itself, cannot amend prior laws. Such implementing resolution can only implement the salary standardization law, not its enabling or prior law. The next case is Bellica versus the Executive Secretary. The facts of the case. The court rendered its decision in Bellica versus Ochoa Jr., declaring certain provisions of the 2013 General Appropriation Act as unconstitutional. On January 13, 2014, Greco Belgica filed the instant petition, seeking to declare all lump sum appropriations in the 2014 General Appropriation Act as unconstitutional, including specifically assailed appropriations. Petitioner asserts that the lump sum discretionary funds in the 2014 General Appropriation Act were passed in violation of the Constitution since these funds are of the same character as the pork barrel funds, which were declared unconstitutional in the 2013 Belgica case and should thus be prohibited. Petitioners sought the issuance of status quo ante order to prevent the use and disbursement of the specifically assailed lump sum funds pending resolution of this petition. The issue of the case is whether all lump sum appropriations, as well as the specifically assailed appropriations in the 2014 General Appropriation Act, are unconstitutional. The Supreme Court said no. A lump sum as well as a specifically assailed appropriation may still be constitutional. A lump sum amount may still be considered as a valid item subject to the President's item veto power for as long as the lump sum amount is meant as a funding source for multiple programs, projects, or activities that may all be clearly classified as falling under one singular appropriation purpose. In this sense, the lump sum effectively functions as a line item that is compliant with the doctrine of singular correspondence as aptly discussed in the 2013 Belgica decision. This singular purpose may be as a general or specific as the legislative department deems it to be, provided that such generality or specificity does not negate the President's proper exercise of his item to veto it. All specifically assailed appropriations are valid items with discernible singular appropriation purpose in compliance with the rule on singular correspondence. The unprogrammed fund, which is to fund the identified programs. The contingent fund, which is to provide funding to meet contingencies or programs yet inexistent and unforeseen during budget authorization. The e-government fund, which is to fund the e-government program that subsumes the strategic ICT project of various government agencies, and the local government support fund to provide financial assistance to the local government units. The e-government fund is constitutional. Its nature as a cross-agency fund requires it to be subject to the determination by the administrative agencies of the ongoing strategic information and communication technology projects in the priority sectors identified by the legislature in the budget. The next case is Lagman versus Pimentel. The facts of the case. On July 18, 2017, the President requested the Congress to extend the effectivity of Proclamation Number 216. In a special joint session on July 22, 2017, the Congress adopted the resolution of both houses extending Proclamation Number 216 until December 31, 2017. In a letter to the President through Defense Secretary Lorenzana, the Armed Forces of the Philippines Chief of Staff General Ray Leonardo Guerrero recommended the further extension of martial law and suspension of privilege of the writ of habeas corpus in the entire area of Mindanao for 1 year beginning January 1, 2018. The issue of the case is whether the Congress has the power to extend and determine the period of martial law and the suspension of the privilege of the writ of habeas corpus. The Supreme Court said yes, the Congress has the power to extend the period of martial law and the suspension of the privilege of writ of habeas corpus. The 1987 Constitution grants the Congress the power to shorten or extend the President's proclamation of martial law or suspension of the privilege of the writ of habeas corpus. Congressional check on the President's martial law and suspension powers thus consists of number 1, the power to review the President's proclamation of martial law or suspension of the privilege of the writ of habeas corpus and to revoke such proclamation or suspension. The review is automatic in the sense that it may be activated by Congress itself at any time after the proclamation or suspension is made. The Congress decision to revoke the proclamation or suspension cannot be set aside by the President. And number 2, the power to approve any extension of the proclamation or suspension upon the President's initiative for such period as it may determine if the invasion or rebellion persists and public safety requires it. And finally, when approved by the Congress, the extension of the proclamation or suspension, as described during the deliberation on the 1987 Constitution, becomes a joint executive and legislative act or a collective judgment between the President and the Congress. Let us now proceed with the cases under the Executive Department. The first case is the Sagisag versus the Executive Secretary. The facts of the case. EDCA, or Enhanced Defense Cooperation Agreement, is an agreement between the Philippines and the United States wherein it authorizes the United States military forces to have access to and conduct activities within certain agreed location in the country. After rounds of negotiations for 2 years, the Secretary of National Defense and the United States Ambassador to the Philippines signed the agreement on April 28, 2014. It was then transmitted to the Senate on the executive's understanding that to do so was no longer necessary. Senators filed a resolution that expresses a strong sense that for EDCA to become valid and effective, it must first be transmitted to the Senate for deliberation and concurrence. The issue of the case is whether the President may enter into an executive agreement on foreign military bases, troops, or facilities. The Supreme Court said yes, the President may enter into an executive agreement. EDCA is constitutional in its arrangement as an executive agreement. EDCA is also considered an executive agreement and not a treaty. Therefore, may be bound through the President without the need for senatorial votes for its execution. Under the Constitution, the President is empowered to enter into executive agreements on foreign military bases, troops, or facilities if, number one, such agreement is not the instrument that allows entry of such, and number two, if it merely aims to implement an existing law or treaty. The manner of the President execution of the law, even if not expressly granted by the law, is justified by necessity. Since the President must take necessary and proper steps to carry into execution of the law, it is the President's prerogative to do whatever is legal and necessary for the Philippine defense interest. Let us proceed to my last case, the case of Sabal versus President Duterte. The facts of the case. Petitioners Sabal and Hakosalem are both residents of Boracay who were earning a living from the tourist activities therein. Respondents, President Duterte, Executive Secretary Salvador Medialdea, and DILG Secretary Eduardo Ano were being sued in their capacity as officials of the government. President Duterte, through presidential spokesperson Harry Roque, announced the total closure of Boracay for a maximum period of 6 months starting April 26, 2018. Petitioners filed a petition praying that, upon filing of the petition, a TRO and/or writ of preliminary prohibition injunction be immediately issued restraining and/or enjoining the respondents and all persons acting under their command, order, and responsibility fro- from enforcing the closure of Boracay. Writ of preliminary mandatory injunction directing respondents to allow petitioners, tourists, and non-residents to enter and leave Boracay Island. The petitioners also argued that its issuance is in truth a lawmaking exercise since the proclamation imposed a restriction on the constitutional right to travel and due process, which is a right to work and earn a living, which is not vested in the President. Petitioners likewise argue that the closure of Boracay could not be anchored on police power because it is not exercised by the executive but by the legislative bodies through creation of statutes and ordinances. Petitioner also stated that the proclamation impinges upon the local autonomy. The issue of the case is whether President Duterte acted within the scope of the power granted to him by the Constitution in ordering the closure of Boracay. The Supreme Court said yes, President Duterte acted within the scope of his power provided by the Constitution. Supreme Court held that the petitioners do not have locus standi because the closure of Boracay would not directly affect their livelihood. due to the fact that the employment of petitioners were not certain, as Supreme Court quoted that there are some days or seasons that they do not have that they do not earn anything. However, notwithstanding the petitioner's lack of local study, the Supreme Court allowed this petition to proceed to its ultimate conclusion due to its transcendental importance. Proclamation number 475 does not pose an actual impairment on the right to travel. The question proclamation is clearly focused on its purpose of rehabilitating Boracay, and any intention to directly restrict the right cannot be deduced from its import, as opposed to several laws which directly impose restrictions on the right to travel. Proclamation number 475 must be upheld for being in the nature of a valid police power measure. Police power has been defined as the state authority to enact legislation that may interfere with personal liberty or property in order to promote general welfare. It consists of number one, imposition or restraint upon liberty or property, and number two, in order to foster common good. The assailed governmental measure draws authority and constitutional provisions under Article 2, Sections 15 and 16, and Article 12, Section 2, which serve as its framework, are primarily concerned with the environment and health, safety, and well-being of the people, the promotion and securing of which are clearly legitimate objectives of governmental efforts and regulations. Petitioners, petitioners in this case have no vested rights on their sources of income as to be entitled to due process. Property rights must bow to the primacy of police power because property rights, though sheltered by due process, must yield to general welfare. Petitioners cannot be said to have already acquired vested rights to their sources of income in Boracay as they are part of the informal sector of the economy where earnings are not guaranteed. No intrusion into the autonomy concern of the LGUs, which recognizes and even puts a premium on the role of the LGU in disaster risk reduction and management, as shown by the fact that number of the legislative policies out in the subject statute recognize and aim to strengthen the powers decentralized to the LGUs. Thank you.
Moving on to case number 11, De Lima versus President Duterte. The facts of the case are as follows. Davao City Mayor Rodrigo Roa Duterte was elected as the 16th President of the Philippines. A key agenda of the Duterte administration was the relentless national crackdown on illegal drugs. This prompted several human rights advocates to heavily criticize the strategies and devices forthwith adopted by the enforcement agencies in pursuing the crackdown. Among the vocal critics of the crackdown was Senator Leila de Lima. Senator De Lima delivered a privileged speech on the floor of the Senate calling a stop to the alleged extrajudicial killings committed in the course of the crackdown and urging her colleagues in the Senate to conduct investigations of the alleged victims. In response, President Duterte issued a number of public statements against Senator De Lima, including denunciations of her corruption and immorality. The statements prompted her to initiate this petition for the issuance of a writ of habeas data against President Duterte. Senator De Lima traces this personal presidential animosity towards her to the time when she first encountered President Duterte while he was still the city mayor of Davao, and she was the chairperson of the Commission on Human Rights investigating the existence of the so-called Davao Death Squad. Senator De Lima concludes that the taking of all public statements of the president into consideration, the issuance of the writ of habeas data is warranted because there was a violation of her rights to privacy, life, liberty, and security, and there is a continuous threat to violate her said rights in the view of the President Duterte's declaration that he had been listening to them with the help of another country. Also, the petition argues that the President Duterte is not entitled to the immunity from suit, especially from the petition for the issuance of the writ of habeas data, because his actions and statements were unlawful or made outside of his official conduct. So the issue in this case is that may the incumbent chief executive be held liable to the court even for the limited purpose under the rules on the writ of habeas data. The ruling of the Supreme Court is no. The petition must be dismissed even without the President invoking the privilege of immunity from suit. Senator De Lima maintains that the presidential immunity does not lie because President Duterte's attacks against her are not part of the official duties and functions of the President. That before presidential immunity applies, there must first be a balancing of interests, and that the balancing favors her because her right to be protected from harassment far outweighs the dangers of intrusion on the office of the chief executive. Presidential immunity in this jurisdiction attaches during the entire tenure of the president. The immunity makes no distinction with regard to the subject matter of the suit. It applies whether or not the acts of subject matter of the suit are part of his duties and functions as president. Furthermore, no balancing of interests has ever been applied to presidential immunity under our jurisprudence. Finally, Senator De Lima asserts that for every right violated, there must be a remedy. No one can dispute the validity of her assertion. We agree with her, but at the same time, we must remind her that this ruling will not deny her any available remedy. Indeed, the Constitution provides remedies for violations committed by the chief executive except an ordinary suit before the courts. The chief executive must first allowed to end his tenure, not his term, either through resignation or removal by impeachment. Being a member of Congress, the petitioner is well aware of this, and she cannot sincerely claim that she is bereft of any remedy. The court dismisses the petition for the writ of habeas data on the ground that the respondent, Rodrigo Roa Duterte, as the incumbent president of the Philippines, is immune from suit during his incumbency. Case 12, Ocampo versus Rear Admiral Enriquez. The facts of the case are the following. During the campaign period for the 2016 presidential election, then candidate Rodrigo R. Duterte publicly announced that he would allow the burial of former President E. Marcos at the libingan ng mga bayani. Duterte won the May 9, 2016 elections. On August 7, 2016, Defense Secretary Delfin Lorenzana issued a memorandum to AFP Chief of Staff General Ricardo Visayas regarding the interment of former President E. Marcos at the libingan ng mga bayani. On August 9, 2016, AFP Rear Admiral Ernesto Enriquez issued a directive to the Philippine Army on the funeral honors and service for President Marcos. Dissatisfied with the foregoing issuance, the petitioner filed a petition for certiorari and prohibition and petition for mandamus and prohibition with the court. The issue in this case is whether the issuance and implementation of the sealed memorandum and directive violated the Constitution and domestic and international laws. The ruling of the Supreme Court with regard to the substantive issues of the case. The President's decision to bury Marcos at the libingan ng mga bayani is in accordance with the law, the Constitution, and the jurisprudence. While the Constitution is a product of our collective history as a people, its entirety should not be interpreted as providing guiding principles to just about anything remotely related to the martial law period, such as the proposed Marcos burial at the libingan ng mga bayani. Section 1 of Article 11 of the Constitution is not a self-executing provisions, considering that a law should be passed by the Congress to clearly define and effectuate the principle embodied therein. Pursuant thereto, Congress enacted the Code of Conduct on Ethical Standards for Public Officials and Employees, the Ombudsman Act of 1989, Plunder Act, and the Anti-Red Tape Act of 2007. To complement these statutes, the executive branch has issued various orders, memoranda, and instruction relative to the norms of behavior or code of conduct or ethical standards of officials and employees. Workflow charts or public transactions, rules and policies on gifts and benefits, whistleblowing and reporting, and client feedback programs. Petitioners' reliance on Section 3, Paragraph 2 of Article 14 and Section 26 of Article 18 of the Constitution is also misplaced. Section 3, Paragraph 2 of Article 14 refers to the constitutional duty of educational institution in teaching the values of patriotism and nationalism. and respect for human rights, while Section 26 of Article 18 is a transitory provision on sequestration or freeze orders in relation to the recovery of Marcos's ill-gotten wealth. Clearly, with respect to these provisions, there is no direct or indirect prohibition to Marcos's interment at the lubingan ng mga bayani. The second sentence of Section 17 of Article 7 is likewise not violated by the public respondents. Being the chief executive, the president represents the government as a whole and sees to it that all laws are enforced by the officials and employees of his or her department. Under the Faithful Execution Clause, the president has the power to take necessary and proper steps to carry into execution the law. The mandate is self-executory by virtue of its being inherently executive in nature and it's intimately related to the other executive functions. It is best construed as an imposed obligation, not a separate grant of power. The provision simply underscores the rule of law and corollarily the cardinal principle that the president is not above the laws but is obliged to obey and execute them. Case number 13, Lagman versus Pimentel. So the facts of this case is that the President asked both the Senate and the House of Representatives to further extend the proclamation of martial law and the suspension of the privilege of the writ of habeas corpus in the entire Mindanao for 1 year from January 1, 2018 to December 31, 2018 or for such period as the Congress may determine. On December 15, 2017, the Senate and the House of Representatives in a joint session adopted resolution of both houses number 4, further extending the period of martial law and suspension of the privilege of the writ of habeas corpus in the entire Mindanao for 1 year, from January 1, 2018 to December 31, 2018. Petitioners are assailing the constitutionality of both the extension and suspension. The manner that the Congress approved the extension of martial law in Mindanao is being put into a question and characterized the same as done with undue haste. The issue of this case is that did the President and the Congress had sufficient factual basis to extend Proclamation Number 216? The Supreme Court said yes. Section 18, Article 7 of the 1987 Constitution requires two factual bases for the extension of the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus. First, the invasion or rebellion persists, and second, public safety requires the extension. A review of the facts in the case at bar similarly leads the court to conclude that the President, in issuing Proclamation 216, had sufficient factual basis tending to show that actual rebellion exists. Events and circumstances disclosed by the President in the present case strongly indicate that the continued implementation of martial law in Mindanao is necessary to protect public safety. After all, what the President needs to satisfy is the only standard of probable cause for a valid declaration of martial law and suspension of privilege of the writ of habeas corpus. In this case, the reasons cited by the President in his request to further extension indicate that the rebellion which caused him to issue Proclamation 216 continues to exist and its remnants have been resolute in establishing a Daesh-ISIS territory in Mindanao, carrying on through the recruitment and training of new members, financial and logistical build-up, consolidation of forces, and continued attacks. In recommending the 1 year extension of Proclamation 216 to the President, AFP General Guerrero cited, among others, the continued armed resistance of the Daesh-inspired DIWM and their allies. As to public safety, the rising number of these rebel groups, their training and predilection to terrorism, and their resoluteness in wresting control of Mindanao from the government pose a serious danger in Mindanao. In a short period after Marawi crisis was put under control, said rebel groups have managed to increase their number by 400, almost the same strength as the group that initially stormed Marawi. Their current number is now more than half the 1,010 rebels in Marawi which had taken the AFP 5 months to neutralize. to wait until a new battleground is chosen by these rebel groups before we consider them significant threat to public safety is neither sound nor prudent. Another issue of this case is that how many times and for how long can Congress, upon initiative of the President, may extend the proclamation of martial law or the suspension of the privilege of habeas corpus. The Supreme Court ruled that, subject to constitutional limitations, Congress has the plenary to make that determination as to the number of times and the period of time of the extension. Case number 14, Honorable Aguinaldo versus Aquino. The facts of the case. On November 29, 2016, the court issued a decision which struck down the practice of clustering by the JBC. On the merits of the case, the JBC assert that in submitting 6 shortlists for every 6 vacancy, it was only acting in accordance with the clear and ambiguous mandate of Article 8, Section 93 of the 1987 Constitution. For the JBC to submit a list for every vacancy according to the JBC, its new practice of clustering in fact is more in accord with the purpose of the JBC to rid the appointment process to judiciary from political pressure as the President has to choose only from the nominees for one particular vacancy. The JBC clarifies that it numbered the vacancy not to influence the order of precedence, but for practical reasons. For example, to distinguish one list from the others and to avoid confusion. The JBC further contends that since every and each vacancy creates discrete and possible unique situation, there can be no general rule against clustering. Submitting separate and independent shortlists for every vacancy is the only way for the JBC to observe constitutional standards of letter A, one list for every vacancy, and letter B, choosing candidates of competence, independence, probity, and integrity for every such vacancy. While JBC maintains that it did not went beyond its constitutional mandate, the court, however, in its decision in November 29, 2016, ruled that the clustering impugned upon the President's appointing power. As such, once the President had appointed from one cluster, he was then proscribed from considering other nominees in the same cluster for every vacancy, even though they are all qualified for appointment. The issue of the case is whether or not the manner of clustering done by the JBC is unconstitutional. The Supreme Court ruled yes, the manner of clustering is unconstitutional. The President's option for every vacancy was limited to 5 to 7 nominees in each cluster. Once the President had appointed a nominee from one cluster, then he was proscribed from considering the other nominees in the same cluster for the other vacancies. All the nominees applied for and were found to be qualified for appointment, but the JBC failed to explain why the why one nominee should be considered for appointment to the position assigned to one specific cluster only. Correspondingly, the nominee's chance for appointment was restricted to the consideration of one cluster in which they were included, even though they applied and were found to be qualified for all vacancies. Moreover, by designating the numerical order of vacancies, the JBC established the seniority or order of preference, a power which the law, rules, and jurisprudence vest exclusively upon the President. The JBC has also failed to present a legal, objective, and rational basis for determining which nominee shall be included in a cluster. Simply saying that it is the result of the deliberation and voting by the GBC for every vacancy is unsatisfactory. The court highlights that without objective criteria, standards, or guidelines in determining which nominees are to be included in which cluster, the clustering of nominees for specific vacant posts seems to be, at the very least, totally arbitrary. The lack of such criteria, standards, or guidelines may open the clustering to manipulation to favor or prejudice a qualified nominee. By arbitrarily clustering the nominees for appointment, the JBC influenced the appointment process and encroached on the President's power to appoint members of the judiciary and determine seniority in the said court, beyond its mandate under the 1987 Constitution. The power to recommend of the JBC cannot be used to restrict or limit the President's power to appoint, as the latter's prerogative to choose someone he or she considers worth appointing to the vacancy in the judiciary is still paramount. As long as in the end, the President appoints someone nominated by the JBC, the appointment is valid, and not the JBC, determines the seniority of appointees to a collegiate court. The last case, case number 15, Araulio versus Aquino III. The facts of the case. When President Benigno Aquino III took office, his administration noticed the sluggish growth of the economy. The World Bank advised that the economy needed a stimulus plan. Budget Secretary Florencio Bush Abad then came up with a program called the Disbursement Acceleration Program, or the DAP. The DAP was seen as a remedy to speed up the funding of government projects. DAP enables the executive to realign funds from slow moving projects to priority projects instead of waiting for the next year's appropriation. So, what happens under the DAP was that if a certain government project is being undertaken slowly by a certain executive agency, the fund allotted therefore will be withdrawn by the executive. Once withdrawn, these funds are declared as savings by the executive, and the said funds will be allotted to another priority projects. The DOP program did work to stimulate the economy as economic growth was in fact reported, and portion of such growth was attributed to the DOP, as noted by the Supreme Court. Other sources of the DAP include the program funds from the General Appropriations Act and program funds or standby appropriations made by the Congress in the GAA. Meanwhile, in September 2013, Senator Jinggoy Estrada made an expose claiming that he and the other senators received 50 million from the president as an incentive for voting in favor of the impeachment of the then Chief Justice Renato Corona. Secretary Abad claimed that the money was taken from the DOP but was disbursed upon the request of the senator. These apparently open a can of worms, as it turns out that the DAP does not only realign funds within the executive, it turns out that some non-executive projects were also funded. To name a few, the 1.5 billion for the Cordillera People's Liberation Army, 1.8 billion for Moro National Liberation Front, 7 million for the Quezon Province, 50 to 100 million for certain senators each, and 10 billion for relocation projects. This prompted Maria Carolina Araulio, chairperson of the Bagong Alyansang Makabayan, and several other concerned citizens to file various petitions with the Supreme Court questioning the validity of the DOP. Among, our, among their contentions was DOP is unconstitutional because it violates the constitutional rule which provides that no money shall be paid out of the treasury except in pursuance of an appropriation made by law. Secretary Abad argued that DAP is based on certain laws, particularly the GAA, which is the savings and augmentation provisions thereof, Section 25, Paragraph 5 of Article 6 of the Constitution, which is the power of the President to augment, Sections 38 and 49 of the Executive Order 292, which is the power of the President to suspend expenditures and authority to use savings, respectively. The issues in this case are the following: whether or not the DOP violates the principle no money shall be paid out of treasury except in pursuance of an appropriation made by law, and whether or not the DOP realignments can be considered as impoundments by the executive. The Supreme Court ruled no, the DOP did not violate Section 29, Paragraph 1 of Article 6 of the Constitution. DOP was merely a program by the executive and is not a fund nor it is an appropriation. It is a program for prioritizing government spending. As such, it did not violate the constitutional provision cited in Section 29, Paragraph 1 of Article 6 of the Constitution. In DOP, no additional funds were withdrawn from the Treasury, otherwise an appropriation made by law would have been required. Funds which were already appropriated for by the GAA were merely realigned via DAP. Lastly, no, there is no executive impoundment in DAP. Impoundment of funds refers to the President's power to refuse to spend appropriations or to retain or deduct appropriations for whatever reasons. Impoundment is actually prohibited by the GAA unless there will be an unmanageable national government budget deficit, which did not happen in this case. Nevertheless, there's no impoundment in the case at bar because what's involved in the DAP was the transfer of funds.